Thank you, Chief Judge Owen, and may it please the court. It has now been nearly 2.5 years since my clients represented to this court in this courthouse that FFRF would never again be excluded from the Capital Exhibit Program on the basis of its exhibit's offensive tone. Yet never again has FFRF asked to display an exhibit in Texas's capital. After months of such silence, the State Preservation Board opted to limit future displays to exhibits that can and are adopted as government speech. Because the First Amendment does not guarantee FFRF either to a government-endorsed megaphone or to access to a closed forum, its claims are moot and should be dismissed. In determining whether the claim is moot, this court looks to the gravamen of that complaint. Over the years of this litigation, that has been narrowed down to one, a discrimination claim, which, as the Supreme Court emphasized last year in Bar Against American Political Consultants, can be resolved in one of two ways: by leveling up and extending the benefit to all people, or leveling down and closing it to everyone. The State Preservation Board has opted to do the latter, by adopting any further exhibits as government speech. The Supreme Court has never created a comprehensive definition of the distinction between government speech and a limited public forum, but it has listed a number of indicative factors going back to Cornelius against NAACP, which consider the nature of the public property at question.
It seems to me what the state has done is to solicit speech and then decide whether it's going to adopt it or not. To me, that's not exactly the state formulating a message that it thinks has public importance.
Your Honor, respectfully, I would disagree with that characterization. The state legislature in Texas Government Code 443.007 allowed the board to create rules about allowing displays, but that's no more soliciting speech than was the case in Walker, which involved the creation of government license plates, which were determined to be government speech. So this goes back to the type of property at issue here is the State House itself, which County of Allegheny recognized the very existence of a message in that property implied government endorsement. Looking to the specific access that was being sought as required in Cornelius, the district...
If I read what the state's trying to do, it's self-evident what they're attempting to do. Our question is whether they succeeded in doing it. What they looked at is I think, is a fairly well-developed body of constitutional law with regard to government speech. That is, the First Amendment is no constraint on the government. Now, the problem is whether they've succeeded in making all these publications actually the expression of the state of Texas as opposed to private individuals. And they start off with a limited public forum, and now the limited public forums, we know, meet the same standards of the First Amendment. But you also have a government forum created by the state for limited purposes that can operate as well. Now, to me, that's the focus of this case: is do they succeed in doing that? I think that's where we are. It's self-evident that's what they're trying to do. I read this. This is not a legislatively drafted in-house thing. This is drafted by a lawyer who's mapping straight off the First Amendment doctrines as best they can. Now, whether they succeed or not, that's to me where we are, if that helps you or not.
Certainly, Your Honor. So looking to the factors that the district court concluded made this a limited public forum in 2016 may be the best way to look through that. And the district court applied the three non-exclusive factors labeled in Walker, and even then concluded that one of those factors, government control, always favored the state. And here in 2020, the state further restricted the amount, or further enhanced the amount of control that was being offered by creating an addition, by going from a shall approve to a may approve regime, as well as giving the board additional control over the content of the speech.
What evidence is there that the state has actually displayed any selectivity?
So since the 2020 change in the rules, there's no evidence in the record at all.
No evidence that there's been any display of selectivity. And is it true that recent exhibits have included some messages that could not possibly have been government speech because they are counter to what the governing law is?
No, Your Honor, because they have pointed to a number. I believe they use speech referring to cannabis. But the Texas is a government of many parts, and that some parts of the government would advocate a change in the law does not make it any less government speech. Going back to the specific factors that the district court highlighted, because in the district court looked to two factors that show government endorsement, which I believe is what Your Honor is referring to here. On page 5 of its opinion, it looked to the fact that two exhibits, one is FFRF's faux nativity scene and the other Thomas More's actual nativity scene, included a statement that disclaimed government endorsement of that speech, as well as footnote 3 of that opinion looked to the absence of a statement in the Texas Administrative Code adopting the speech. The 2020 rules have addressed both of those issues. Every exhibit being put forth in the Capitol has to have a statement attached to the exhibit, a sign effectively, identifying the sponsor of the speech, as well as including the endorsement of the board. That eliminates any confusion over whether or not the government is actually endorsing this speech. That it is a piece of speech that some parts of the government may not agree with does not make it any less government speech than, for example, a government license plate in Walker proclaiming that University of Oklahoma would be not government speech. Governments are allowed to have different messages. There doesn't need to be a single coherent message for it to be government speech under current doctrine. So in addition, there...
It's just a way to allow the government to censor the speech that it wishes to censor by saying that's not part of the collective government viewpoints. You can have many government viewpoints, but this is not one of the allowed government viewpoints, just every once in a while when you don't like a display.
No, Your Honor. As Judge Higginbotham pointed out, the viewpoint discrimination rules simply don't apply to the government. It is the government, as Summa recognized, is entitled to say what it wants. It doesn't always have to say the same thing, but it is entitled to choose what it wishes to say.
Well, we have to get to whether this is even, would the reasonable person think this was government speech? And the district court said they would not think that this was the government speaking about all of these displays from all these various groups. So we're not, I mean, that assumes that you won by saying, well, the government can speak that way.
So the district court found that based on two factors: the presence of a sign disclaiming responsibility, which, as I just mentioned, we're now having signs that say the exact opposite, which would reaffirm to the reasonable viewer what County of Allegheny against ACLU found, that the very presence of an exhibit in the State House, or in that case the county building, implies a government endorsement because of the significance of the building. So any confusion that was created by the disclaimers of responsibility on FFRF and Thomas More's exhibits have now been eliminated because the government has put a sign up saying that they endorse the speech. Now that imposes other restrictions on the government, for example, those that are part of the Establishment Clause or the 14th Amendment, or half a dozen other restrictions on government speech, but it does take it out of the realm of where the viewpoint discrimination rules are applicable. So, and even if that were not the case, there is another additional problem of whether there is an ongoing violation. In their briefs, FFRF repeatedly point to displays specifically in selectivity between the Thomas More exhibits that were in 2014 and 2015. They can't point to any evidence that those were repeated after the change in the rules because it doesn't exist. There has not been a nativity scene of that type in the Texas State Capitol since 2015. And because, as in Barr, even if you were to disagree with me about whether this was government speech, as in Barr, we can level up or we can level down. And so we have eliminated the type of discrimination that FFRF has identified in their briefs. So there's no ongoing violation that fits within the realm of Ex parte Young or Wheeling Bridge. And so as a result, because the plaintiff bears the burden on both of those elements, that is fatal to this particular injunction. If the court has no further questions.
We wait for the Supreme Court to speak in the flag case.
In the flag case, Your Honor, no, I don't believe that that's necessary. To the extent that the court needs to wait on anything, and it doesn't, because what I'm about to say doesn't actually change the analysis, I would like to bring to the court's attention that since briefing closed in this case, the State Preservation Board has proposed an additional change in the rule that would repeal 1111.13 entirely as unnecessary. That rule is not necessary because, as it is, the State Preservation Board can put up exhibits that are adopted as government speech, but the board itself has determined that it is no longer necessary to have that rule. It has been proposed, the comment period has closed, but it has not yet been formally adopted, and I don't know when or if it will. But I wanted to make sure the court was aware of that. If the court has no further questions, I will reserve the rest of my time for rebuttal. Thank you.
Good morning, and may it please the court, Sam Grover on behalf of the plaintiff appellee, the Freedom from Religion Foundation. It is undisputed that the state of Texas engaged in unlawful viewpoint discrimination when, in 2015, it removed the foundation's Bill of Rights display from the Texas Capitol's exhibit areas. The state engaged in unlawful viewpoint discrimination again in 2016 when it rejected the foundation's second application for a display, saying, quote, "Any application to display the same exhibit, which was removed last year, will be denied for failure to satisfy the public purpose requirement." The gravamen of the foundation's complaint is that the state is using the public purpose requirement to censor speech it finds undesirable, and that despite the state's amendment to the Capitol exhibit rules, nothing prevents the state from continuing to cite the public purpose requirement as a justification for censoring the foundation's speech in the future. Now, the state claims by fiat to have converted a long-standing public forum into a venue exclusively for government speech. But whether a public forum exists is a legal determination for the courts to decide based on an analysis of facts, and in this case, the record definitively demonstrates that the state's revised rule has not meaningfully changed how the state handles exhibit.
Counsel, under TAC, paragraph 3, it provides the chief test of what constitutes a public purpose is that the public generally must have a direct interest in the purpose and the community at large is to be benefited. Who determines the benefit and by what criteria? What's that assessment?
Your Honor, there are a number of factors that go into that determination. It is the state's determination to make.
I understand it's the state's determination. My question is by what metric?
There are numerous factors, descriptive words that go into the public purpose requirement, many of which Governor Abbott cited in his letter to the State Preservation Board demanding the foundation's exhibit be removed.
I'm sure you're familiar with Justice Scalia's opinion of what's beef, that's what's for dinner?
Yes, Your Honor.
Yeah. You recall that in his opinion, what he does is to detail in considerable detail exactly how the advertisements are made. That he makes the observation, well, of course, the secretary doesn't write these advertisements for beef. It's done by staff, and he goes through the absolute process by which it is controlled entirely by the secretary. Precisely what is said and what's not said, and that sets out in many ways the metric by which we gauge the government speech or not. Is the government really speaking here, or not? In which event, it's just a political process.
Yes, Your Honor. And in terms of whether this is government speech. The government speech doctrine is a narrow exception to viewpoint neutrality, which is required under public
Well, that's
forums.
of course, and that's the focus of my question: is viewpoint neutrality. Who makes the determination of the public benefit?
Who within the government?
I don't mean the individual, but is it?
It's the State Preservation Board initially. In this case, the facts demonstrate that after the State Preservation Board made that determination that the foundation's exhibit did meet the public purpose requirement, Governor Abbott nevertheless had the display censored. There's nothing in the rules that permit Governor Abbott to do that, but he went ahead and did it anyway, and there's nothing in the revised rules to prohibit him from doing it again. Now, the record demonstrates here that there have been displays put up under the revised rule. The pro-marijuana decriminalization exhibits are an example, that are incompatible with government speech. An exhibit that advocates for the government to change the law is not a statement coming from the government itself. And if such exhibits were considered to be government speech, the state would be, quote, babbling prodigiously and incoherently, to borrow a phrase from the Talby Tam. Other recent exhibits under the revised rule equally incompatible with government speech include exhibits criticizing Texas's policies on mass incarceration and advocating for criminal justice reform. That comes in the record on appeal at 2315 to 16. Now, the state claims for the first time in its brief on appeal, and without evidence in the record, that these recent pro-marijuana exhibits and criminal justice reform exhibits were approved under the old exhibit rule, but that cannot be the case given the timeline. The revised rule became effective July 20, 2020. The exhibits in question were put up in February, March, and April of 2021. And the Preservation Board's policy both before and after the revised rule was put into effect is that no exhibit application will be considered more than 6 months in advance. That comes in the record on appeal at 542. So given that timeline, these exhibits, which are incompatible with government speech, were put up under the revised rule. And
What's the best way to distinguish Walker case? I was on that case. Justice Alito wrote a very fine dissent, but it's a dissent. The idea that the state is not really rooting for OU or Whataburger or whatever, but so that the fact that the state may be schizophrenic in all of the things it's rooting for, and I don't mean disrespect to people who actually have health issues, that doesn't mean that that can't be government speech. What's your best way around Walker?
Well, the court itself, the Supreme Court itself, has identified Walker as likely marking the outer bounds of the government speech doctrine that comes from the Talby Tam. And rather than, all forum analysis cases are, in some sense, confined to their facts. It's a fact-sensitive determination, and license plates are very different than temporary displays in an area within the Texas Capitol designated as a limited public forum. Rather than distinguishing Walker, the foundation has applied those same factors to this case, and the district court did as well. Those factors are an application of summum in the first instance, and under those three factors, this is still definitively a public forum. So whether the government has historically used the space for government speech, there's no history of the government using these areas of the Texas Capitol for its own speech, and they have been a long-standing limited public forum.
Well, is there a law that says you can't change? I mean, it seems to me the state has a right. Maybe I've never used it before, but we're going to designate this area now. I mean, there's no case that says you can't do that.
Oh, yes, Your Honor. The state absolutely could do at least one of two things. It could definitively close the forum. It could level down the forum. It has not done so in this case. The forum remains open, and the record demonstrates that it's continuing to allow all comers to put display applications forward. The state also could erect permanent monuments in those areas, which are legally distinct from the temporary exhibits that it currently welcomes in the Capitol. The state argues that the relevant space to be considered is the Capitol as a whole rather than the Capitol's exhibit areas, but that's not correct. The relevant area is the specific location at issue, and the case is also...
The direction of those monuments, since you rely on that, the history of that doesn't really support that. What happened with the monuments is when they undertook to redo the Capitol for the office structures and had to create all the office space down underneath. And they removed all the monuments. And then in response to that, I think it was Bullock Authority pushing this. What they created was came back with was an entire distinct program for what goes back in. They appointed museum curators now in charge, who for purposes of, then they made the determination as to placement and replacement, et cetera, et cetera. So that history is quite distinct from what's happening here.
Yes, Your Honor. In summum, both the medium and the location of the speech were considered in conjunction, which is obscured. That point's obscured a bit if you look exclusively to Walker, because that case read in isolation treated government IDs as both the medium and the location of the speech. But in summum, both the medium and the location of the speech were considered in conjunction. The summum court's entire conclusion was premised on the idea that speech in a park can be treated differently depending on whether the medium of the speech is transitory, that's the word they use, or permanent. And a good application of the medium and location in conjunction comes from Higher Society v. Tippecanoe County, where after a county board voted and declared a courthouse grounds to be a closed forum and attempted to adopt a new policy where the county was going to sponsor speech there, the court agreed that sponsored events in the courthouse grounds continued to be private speech under essentially the Walker factors. Now, even if the entire Capitol grounds is considered to be the relevant space, state capitals throughout the country are home to limited public forums of the exact same nature as the one Texas runs. That is, in fact, the rule rather than the exception. At least 40 state capitals allow private exhibits on their grounds. The record doesn't include an exhaustive accounting of each state capital, but does reveal that such forums exist in at least Arkansas, Florida, Illinois, Mississippi, Rhode Island, Washington, and Wisconsin, in addition to Texas. That's Record on Appeal at 716. Regarding the second Walker factor, whether a reasonable observer would attribute the speech to the government, the district court concluded that an observer familiar with the history of the Capitol's exhibit areas and the wide range of displays that have been put forth there would certainly conclude that these exhibits are private speech. The district court further noted...
Current displays, right?
Yes, Your Honor. There's nothing in the revised rule that changes displays in a meaningful way that would inform a reasonable observer.
They're still taking all comers.
They're still taking all comers.
Even if it...
And
Does it matter whether you win on that? If they had been not allowing a bunch of other people, would that weaken your argument?
No, Your Honor. If the government is censoring a greater number of speakers, that doesn't mean that it's not also censoring the foundation. In terms of messages now on displays, the state is incorrect to have said that there's now a statement of government endorsement on exhibits. That's simply not true. Instead, exhibits must identify the state official sponsor and must indicate that the State Preservation Board has approved the exhibit for display, which is not the same as adopting it as government speech. In every public forum across the country, private speech that's displayed has been approved for display. That's not incompatible with a limited public forum.
To what extent does it matter for your case that the speech was originally approved and then vetoed by the governor, for lack of a better term? Does that matter at this stage? Because is it your position that even if the regulations are okay, the fact that the governor can always veto and that there's a history that the response that this would not be allowed, is that what, or is that part of the case moot?
Your Honor, the court need not consider that because the part of the government's policy, the public purpose requirement on which the governor relied in censoring the speech still exists and is materially unaltered in its present form. The word morals was removed, but that's one of several factors of the public purpose analysis that the governor cited. And the state has never argued that the word morals was the exclusive.
But the policy doesn't give the governor a veto right.
Yes, you're
The
correct.
current or the former one.
Yes, Your Honor. And so the way that the government initially censored the speech remains viable under the revised rule. Yeah, there's nothing preventing the governor from doing the same thing that he did in 2015 under the revised rule. The third Walker factor is the level of control exercised by the government over the speech. And it's important here that the government is not the originator of any of the messages put up in the Texas Capitol. The state does not create the exhibits in the first instance, rather it's private parties. No, Your Honor, except...
Say, well, this month is this group's history month or something, and we're going to make sure that all the exhibits are
No, Your Honor, there's...
curated for that reason or something.
No, there's no curation or suggestion by the government as to what types of speech should be offered at any given time. The government also doesn't own any of the exhibits. Ownership remains with the private organizations, which the Supreme Court noted was relevant in Walker at 216 and in Sumum at 473. Private speakers not only design and own the exhibits, but they're also responsible for the costs of assembling, displaying, and removing their exhibits, which is in the record at 2217. Likewise, the state is wrong to suggest that it has gained the ability to determine the length that any exhibit may be displayed under the revised rule. The state already reserved the right to consider extending the time for any exhibit to be displayed under the prior rule. That's ROA 540. And the record contains examples of applications seeking longer display periods, ROA 433 and ROA 440. Finally, for government control, Justice Alito recently pointed out during oral argument in the Boston v. Shurtleff case that government control standing alone cannot be the be-all and end-all in determining whether speech is private or government speech, because censorship itself is a form of government control. The government cannot create a forum while claiming to retain the right to censor whatever speech it wishes. That's not a permissible exercise of government control, and that's precisely what the state of Texas is seeking to do in this case. There's also the issue of voluntary cessation, which is an important exception to the mootness doctrine, but it simply doesn't apply in this case where the defendant's altered conduct hasn't ended the challenged practice in the first place. Now, the government may bear a lighter burden than a private entity to prove that challenged conduct will not recur, but that lighter burden is based on the rebuttable presumption that the government actors will act in good faith and not based on self-interest or personal animus. And in this case, Governor Abbott has a well-established history of personally objecting to the foundation's speech, including celebrating on social media when he ordered the board to remove the foundation's exhibit. It's ROA 25. Even if the court ignores Governor Abbott's personal animus and applies the relaxed standard, the government still is required to make it absolutely clear that the allegedly wrongful behavior could not reasonably be respected to recur. This court replied that relaxed standard arguendo in Speech First Defendus, where it considered three relevant factors. Under the first, whether the state had made a controlling statement, future intention. The state has not made such a controlling statement regarding its use of the public purpose requirement, did not make such a statement at this court's invitation after the prior appeal. Instead, the state did make a definitive statement through the revised rule that it fully intends to continue operating the public purpose requirement and to find speech it finds undesirable to violate the public purpose requirement.
Do you think there's any reason to wait for the Supreme Court?
In Boston v. Shurtleff, all forum cases are confined to their facts to a certain extent. Flags are a bit different of a situation. I don't believe that there's any reason to wait. The timing of the state's adoption of the revised rule could not be more self-serving in this case. The state didn't revise its rule when Mattel v. Tam was decided in 2017, despite its continued claim, already refuted by this court, that the case marked a sea change in free speech jurisprudence. It only revised the rule after remand of this case.
You didn't have to submit a new application under the new rule, that you have this statement that says, you know, this will always be the case? Is that your whole case relies upon that?
Well, this court on the previous appeal found that the government's statements made during litigation were insufficient to strike the original rule or the public purpose requirement. The government has erected a wall here and is now inviting the foundation to bash its head against it. And frankly, that's not how chilled speech works. The foundation's speech was chilled. The government said so in no uncertain terms, that it would not accept a future application, and the revised rule does nothing to change that. Thank you.
Thank you. Just a few quick points. Judge Higginbotham, in response to your question, the legislature has allowed the State Preservation Board to decide what goes up in the Capitol, and that's in Chapter 443 of the Government Code. Second, in response to opposing counsel's reference to a snippet of the Mattel opinion that refers to babbling incoherently, that is taken out of context. The biggest factor in Mattel was the lack of government control. There, the only government connection to the speech at issue was registration. And pointing to page 1760 of that opinion, Justice Alito noted that if that was enough to transform private speech into government speech, there would be no First Amendment left, because trademarks of books also have to be registered. That is not the same as an exhibit placed in a prominent location inside the very heart of Texas's government, its Capitol building.
What is the state's position about the organization submitting a new application?
Your Honor, the organization needed to submit a new application to put up an exhibit. So the fact, and it had 6 months to do so. If you go by our first brief filed in this court saying that we would never again repeat this conduct, they had nearly 2 years to submit an exhibit to put it up in the Capitol.
They freshly did one today.
So
is it your position that the state bars them forever, or that they would be looked at freshly under the new rule and would have a chance just like every other group?
So at the moment, due to the proposed rule change, the board is not accepting exhibits pending resolution of the change that was proposed after the briefing was closed. Apart from that, if they were to find a sponsor to go to the board, they would be given the same consideration. And there might be some moderation of tone, there might be some changes required by the board, as happened here when they had to make substantive changes to their exhibit when Representative Howard refused to sponsor the original exhibit. But they would be considered like everybody else.
Does the governor have the power to override the decision of the group? Did the governor have the power under the old policy and under the new policy?
He did not. The governor recommended to then Director Sneed to take it down, and Director Sneed determined that that was the appropriate action.
Within 24 or 48 hours, didn't he?
After calling each member of the group separately, as reflected in the record. So
now does he have the right to, could he call the director today if there was a new one and they would?
He could call the director, and the director
take it down, so he would maintain the governor doesn't like this, y'all need to take it down. Under the new policy, is that still the way it works?
Under the new policy, the board would be considering whether or not to adopt it as government speech. And so if the board collectively decided it was not appropriate, that would be how it worked.
Right, but after the board had decided under the new policy that it was government speech, if the governor called after the fact and said it's not going to be government speech on my watch, then would they reconsider?
Under that hypothetical, the State Preservation Board retains the ability to shorten the exhibit period. And if it determined that it was not appropriate as government speech going forward, it could take it down. But it could do that precisely because of the level of control that Mattel did not, that was not an issue in Natal.
Remind me how the people get on the Government Preservation Board?
Most of them are independently elected individuals.
Independently elected to that board?
So the ex officio members include the governor, the lieutenant governor, the Speaker of the House. Then there are a member of the House of Representatives selected by the Speaker, a member of the Senate selected by the lieutenant governor, and a outside member of the public. None of those individuals respond or report to the governor. So they would have an independent vote on this board, and if the board determined it was not appropriate for government speech, they could shorten the period. So looking to another focus of that is the shortened period, the permanence, as my colleague on the other side pointed out from Summum.
Well, suppose you had a member of the legislature that supported Roe v. Wade, and they had a message that was basically to support Roe v. Wade, and they sponsored that and brought that. Would the board have the authority to say no? That's not in the public interest. How would you determine whether it's in the public interest or not? As I read this regulation, if the board decides through the processes that are quite very detailed, if they go through that process, then they can reject it. It's not we don't choose to adopt that as government speech. Does that create a problem for you?
So
in other words, the basis for rejecting it would be it's not in the public interest because our government policy here is not supportive of Roe v. Wade.
So under the old rule, and this highlights that the rule has in fact changed. Under the old rule, if a representative came to the board and said that that's what they wanted to do, there was a shall approve language, and that would have gone up. Under the current rule, the board would discuss as a group whether they wanted to adopt that as government speech, and they would have the choice whether or not to do so. Under its current membership, I suspect that it would not. Under future membership, it may be different. Okay. But that's part of what it goes into having a government able to have the right, as recognized in Summon and Walker, to put up the message as it wants to. And that is what we have preserved here, and why the decision below should be reversed. Are there any further questions?
No. Thank you.
Thank you, Counsel. The court will take a brief recess.